We have some breaking news for you. This is a live picture from Fulton County, Georgia. Former President Donald Trump is expected to turn himself in any minute now in the election interference case. He will be fingerprinted and photographed before being released on $200,000 bond that was negotiated previously. Trump's former attorney, Rudy Giuliani, turned himself in yesterday. He was fingerprinted and had a mugshot taken. You can see it there. That was inside the Fulton County Jail. Trump, Giuliani, and 17 co-defendants are accused of plotting to overturn the results of Georgia's 2020 presidential election. Court TV will bring you coverage when Trump turns himself in. In the meantime, Court TV's own Julia Janae digs deep into one of the most serious charges against Trump, which is violating the state's RICO Act, a charge usually reserved for mob bosses.
The RICO Act in the U.S. operates as a catch-all tool for prosecutors to bring to justice those who are using a legitimate business or organization as a front to carry out sinister plans. RICO is an acronym for racketeer, influenced, and corrupt organizations. Many states have their own version of the federal act. It was enacted federally in 1970 and was historically used to round up crime family mobsters like John Gotti and Frank LaCasio in the 80s and 90s.
Some have called it the mob trial of all mob trials, the U.S. government versus John Gotti.
The types of defendants RICO has been used against has varied greatly over time. Police departments accused of corruption, a health insurance company for underpayment of claims. Even the MLB have been the subject of RICO claims, which can be criminal or civil.
One man ain't no enterprise.
One man ain't no enterprise.
The government needs to start telling us.
More recently, the law was used in New York to convict singer Robert R. Kelly for the trafficking of underage girls for sex, and to charge rapper Young Thug of the YSL gang and former President Donald Trump on charges he conspired to unlawfully change the outcome of the 2020 election. To successfully bring a RICO case, the filing party has to prove there was an enterprise, a common scheme that all the actors helped accomplish, and overt or clear acts to further that enterprise. So why bring a RICO case and not just criminal conspiracy charges? With RICO, the underlying acts don't have to be chargeable crimes. Plus, if those acts happen in different states, they can all fall under the same RICO umbrella.
Overt acts are not necessarily crimes under Georgia law in isolation, but are alleged to be acts taken in furtherance of the conspiracy.
It's also not required that all the actors agree to one scheme at the same time, like a ring of burglars targeting a neighborhood. RICO only requires that the person charged or the ringleader had an overall plan.
All right, that was Julia Janae reporting for us, and we are still taking a look at the motorcade. Trump, he is making his way to Fulton County Jail to turn himself in, and this is a shot of him arriving at the jail tonight. We had heard that he was going to arrive at 7:30 tonight to turn himself in, and it's just 7:33 now, Eastern time. And so he left Newark, New Jersey earlier this morning, got on the plane and headed here to Atlanta, Georgia. I do want to bring in our guests tonight. We do have trial attorney C.K. Hoffler, also Seth Baronsway, who is a litigation and constitutional attorney. Folks, what do you have? Tell us what you're thinking as we're watching the motorcade here getting to Fulton County Jail. Why don't I start with you, Seth?
Well, it's certainly a unique moment in history. It is true that this is the fourth time that the president is turning himself in, so he'll be out on bond in 4 cases. But this is nevertheless unique this evening because you have a case where a former president of the United States has been accused of a RICO enterprise. And this is therefore something that is substantively unlike anything we've seen before. This is therefore on the substance a very unique and novel case, at least in terms of the defendant and the enterprise at issue. And it's also a unique case in this context from a procedural standpoint, because although at the moment you've got 19 defendants, I can assure you that several of them will drop off and plead, and each of those will fall like a brick onto Donald Trump, which exposes unique risks. So certainly we have a unique moment in history, particularly in light of the unique nature of this case.
It is a unique moment. All right, Seth, thank you. And Michael is still with us tonight. Michael, I want to bring you in here, too. You can ask some questions as well.
Yeah, CK, hi, Michael Ayala here. Great to see you, CK. Thanks again for joining us here tonight. The question I want to ask you, earlier today, we saw a situation where one of the defendants in the case has decided to not waive his speedy trial rights, and Fani Willis said, no problem. You know, she's got this under control. I want a trial date in October. She was granted a trial date in October. Hard to believe that they'll be able to get all this together at that time. So what are some of the issues at play? First of all, with a defendant not waiving his right to speedy trial and Fani Willis putting her foot down and saying, we're going to go to trial in October.
Well, the one thing that we have to realize is that Fani Willis, the district attorney of Fulton County, has had 2 years to investigate, to plan, to research, and to look at every single aspect of this case from the vantage point of all 19 defendants that she decided to charge. That's the first thing. She intended, articulated at the time of the indictment, that she was planning on having a speedy trial. She wanted a trial date in October. So what we are seeing now is a district attorney who is sticking to her guns. There are a lot of procedural issues. As you know, Michael, there are going to be motions on top of motions on top of motions. We've already seen motions to remove the case to federal court. And my prediction on that is that the case will be remanded back to state court. Any defendant can seek to remove a case to federal court, but in this case, because of the way that it has been structured, the way it's been executed, the way it's been planned, the way it's been researched, my prediction is that it will be remanded back to state court in Fulton County, despite the numerous motions that every single defendant is expected to file. And the district attorney has made it very clear that she is going to proceed and will have a trial date in October. So historic, this is beyond historic, Michael, on so many levels, from a constitutional level, from just the issues, from the RICO charges, and there's a reason why it's being tried under RICO. This is a RICO case. It's because Georgia RICO statutes are unlike the statutes in any other state in this nation. And I think that is very important. So I think that people must realize that this district attorney has looked at these issues and done a lot of work for a period of 2 years. And all of these legal challenges that we are about to see, the motions have been completely anticipated because she had the benefit of bringing her case when she was ready.
Yeah, preparation is what it's all about. Seth, quickly, I just have a question for you. You know, the historic nature of this cannot be overstated. What we're talking about here is a prosecutor saying that a former president is the head of a criminal enterprise. That just put that and think about that for a little while. But here's a question, and it was raised a little bit by CK, where this case might end up. The big question is, obviously, President Trump, a couple of the other defendants are going to want to move this to federal court, believing that's a better forum for them. And the question is, for him, were the acts that he's being accused of part of the furtherance of his office, or whether they were just acts that fall outside of the duties of his office? That may have a major bearing on whether this ends up in state court or federal court. Your thoughts on that?
Well, absolutely, and I think you've really nailed the distinction on the head. Mark Meadows has already tried this route, and the president probably will eventually, as well as some of the other defendants. The problem is in that distinction, and the allegations in that regard are not that these were matters and conduct that occurred within the scope of their employment as employees of the United States government, but rather they were trying to overturn the election and to try to overturn the results of an election for the United States government. This is absolutely out of the ordinary and reasonable scope of the job. Criming a coup is nothing to do with the job description. So it absolutely will probably see attempts to remove it to federal court. The process is, first, easy. The defendant files a 2-page notice of removal that goes to the federal court, but then there is a hearing and a motion to remand back. And I agree, it will be remanded back to the state court. This is not going anywhere in the long term. We're going to have a trial. in some manner or fashion, it will deliver a verdict before the election. And this case is going to be a huge uphill battle for the former president. And really the centerpiece and an example of this case of the enterprise, of course, is the phone call to Brad Ratzenberger, where he said that he wants him to find 11,780 votes. And, you know, you really can't get much more blunt than that. If you look at the counts in the charges, it's very simple: submission of false statements, submission of false documents, felony computer breach. And this is all in furtherance of the enterprise. So this is really a historic case. It will ultimately lead to constitutional issues as well. Really one of the little discussed issues, which will really weigh very heavily, especially next year, is whether the disqualification clause under the 14th Amendment, Section 3, is something that bars the president, the former president, from running again as a matter of law. So keep that in the back of your mind. But you will absolutely see that there will be a lot of jockeying for process. But at the end of the day, there will be no form over substance. We will see a trial in this court on all of these counts.
All right, Seth, thank you so much for your insight tonight, as well as to CK. We do want to get a quick break in here. Former President Donald Trump, as we mentioned, has arrived at the Fulton County Jail tonight. He's turning himself in on charges that he interfered with the 2020 election. He is expected to be booked, then released on $200,000 bond that was already negotiated. Keep it here. You are watching Court TV, your front row seat to justice.
Tonight on Closing Arguments, you've heard of Florida man. What about Florida woman? Our legal experts break down each alleged crime and the common thread between them.
Closing Arguments, coming up next, only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
Court TV, Legendary Trials. Go to courttv.com/legendary trials to find out how to watch.
And welcome back to Court TV Live. I'm Kelly Craft. Prosecutors are pushing to take former President Donald Trump to trial as early as October. This is according to a court filing today. This comes amid heightened security at Fulton County Jail in Atlanta, where Trump has arrived to turn himself in on charges tied to alleged efforts to overturn the 2020 election. He has agreed to a $200,000 bond. 18 co-defendants have also been indicted in the case, including former Trump attorney Rudy Giuliani, who surrendered yesterday. They were all indicted on more than 40 counts, including violating the RICO Act, solicitation of violation of oath by a public officer, as well as conspiracy. I do want to bring in our guests again to talk about this historic moment. And Seth, I do want to start with you. Actually, CK, I want to talk with you again. You know, you had mentioned earlier about, the District Attorney of Fulton County, Fani Willis here, having 2.5 years to investigate this case. We have Donald Trump, who is running for president, which requires a lot of work. So you have all these legal cases. Then he's running for president. I mean, it's a lot to handle. What do you think, CK?
Well, I think it's going to be an uphill battle for the president without a question, a tough fight for the president and the other defendants. I agree that many of these defendants will peel off and turn evidence against the former president without a question. But I do think that the District Attorney Fani Willis, who is a superb trial lawyer, well prepared, very skilled, comes from a legacy of trial lawyers. She is going to and her team are going to put everything into this case because, again, she had 2+ years to put this together. By the same token, the president has hired new counsel, a very, very able criminal defense lawyer who I also know. I know both of them. In Atlanta, Steve Sadow. And so this is going to be, of course, a very significant piece of litigation. Constitutional issues, local issues, state, federal. But at the end of the day, despite all of the motions that are going to be filed and all of the delays that will be sought, it is my thought, it is my prediction that the District Attorney, Fani Willis, is going to have her day in court, her team will have their day in court before the elections because they've had the opportunity to look at these issues, study these issues, predict and prepare, and they're very, very skilled lawyers. And that takes nothing away from the expertise and the excellence of the skilled lawyers that the former president and other defendants will have. It's just that these allegations, if true, and if the evidence is there under Georgia RICO statute, will be very serious and very difficult to escape. And this district attorney, Bonnie Willis, knows that. And she's crossed every T and dotted every I and had almost 2.5 years to do it. We do not need to underestimate the brilliance of this district attorney and her team. And we also don't need to underestimate new counsel for Donald Trump, who is a well-respected criminal defense lawyer. But if any of these allegations are true, and if they can be upheld under RICO, then the president is going to have a very difficult time. And as we all know, if it's in state court, Fulton County, where I predict it's going to be remanded back, then there's a mandatory 5-year sentence that this former president and other defendants will have to serve. And that is something that each of these defendants is thinking about. And that's why I predict that many of them are going to turn evidence, because after all, in a RICO, a scheme, this type of enterprise, it's the head of that enterprise that is critically important. And the other players, while very important, many of them have less significance than the former President Donald Trump, if all of these allegations are to be believed and if the evidence is there to support it. And again, 2 years is a long time to investigate a case and cross every T and dot every I.
Yeah, it is a long time, CK. Michael also has a question for you, so I want to get Michael in here.
Yeah, first thing I wanted to say was just listening to you, CK, it just makes me realize again the unprecedented nature of this situation. It's just, you're talking about prison time for a former president. I mean, it just blows my mind. But here's what I wanted to ask you. The president has tweeted out, and we know he likes to communicate on social media. As a matter of fact, one of the main weapons for Fonnie Willis in this case is his use of social media and sort of getting this criminal enterprise to do what he wanted them to do, allegedly. But he has tweeted that he plans to release irrefutable evidence of election fraud in Georgia. So my question to you is, let's assume that he does have that. Is that a defense in this case?
I think it would be evidence that could be persuasive, but this is a RICO case. So if they're able to prove the elements of RICO and they've got the evidence to sustain that, that will be something that will diffuse, that will perhaps muddy the waters. But if this district attorney has the evidence that she believes she has to prove her RICO case, then and the jury believes that, the jury, because this is going to be a jury trial, believes that the elements have been proven and the jury is prepared to convict a former president, then even if the president does have irrefutable evidence, all that irrefutable evidence, presumably the president and his allies have tried to present that previously. And everyone has seen that. Now, there might be something new that's out there, but I dare say that the time for all of that evidence and information would have been before, and it was well known that this case was investigated for over 2 years. So I'm not going to predict that will be something that will not be considered, because evidence is evidence, and both sides will consider the evidence and lay the evidence, and there's going to be a defense. But if what we think is going to happen, which is many of the defendants are going to turn evidence because they do not want to take the risk of being convicted and serving a mandatory sentence. And by the way, there is not going to be any pardon power. Under Georgia law right now, the governor will not have the power to pardon anyone as it stands under Georgia law. This is not a federal case. We're not talking about a presidential pardon. That is why this is historic on so many levels. And that is another reason why so many of these defendants, I believe, are going to turn evidence against the former president of the United States.
And CK, when
that's
you're talking
what makes
about
this case historic.
CK, when you're talking about people turning, I mean, even if you want to talk about the cost associated with defending yourself in a case like this, a case where she had so much time to prepare, you need to bring attorneys in there. It's going to cost you a lot of money. And some of them might just be like, okay, wow, I don't want to put my family through this. I don't want to put this financial strain on my family. So I am going to provide some information here.
Absolutely. The cost is going to be astronomical. You know, one of the things that's also unique about this case, Kelly, is that we're seeing lawyers being charged. Lawyers, we know, we have ethical duties, professional duties, but one thing that we know, we cannot be part of a criminal enterprise. We cannot perpetuate crimes. And if the allegations are true, these lawyers are also have a very tough battle. So many of some of these defendants probably do not have resources sitting around to hire the best defense attorneys to help them to assist with their case. This is incredibly, I imagine, painful and strenuous on these defendants, no matter how many of them were smiling when they were arrested or when they had to be booked. I'm very certain that they feel the pressure of this. How could they not feel the pressure of this? So this is a very, very significant case, a historic case, a very costly case, a very time-consuming case, a very taxing case. But I just want everyone to remember the 2 to 2.5 years that District Attorney Fonnie Willis had to put this together and to cross every T and dot every I with a lot of criticism. And this tweeting that is happening right now, even though this is a young judge, this is a new judge on the Superior Court in Fulton County, I believe that this judge is not going to be afraid to hold in contempt anyone who violates any order as it relates to tweeting and the media, because at a time like this, as in other cases, as in the case in the District of Columbia, there are going to be limitations and restrictions on what a former president can tweet, just like any other case. So I think this is going to have very significant ramifications. Just imagine a world where, because of tweets, the president is constantly tweeting. By the way, for a very long time, there are many people that are involved in this alleged criminal enterprise that have been criticizing the district attorney of Fulton County for a very long time and continue to do that, despite knowing, and I'm sure legal counsel has advised them, doing that. So I think that this is going to be historic on many levels, and there are going to be a lot of twists and turns.
All right, CK, thank you so much for your information tonight. Really appreciate you joining us. And also thanks to my colleague, Michael, for being with us this hour. Also, as I mentioned, want to thank Seth. He joined us earlier as well. I'm Kelly Craft. It has been a pleasure being with you tonight.